So business owners, if you think signing contracts you don't completely understand is normal, here's what this actually might be costing you. Business relationships that you can't end without significant financial costs, or terms that you didn't fully understand initially, but over time you'd realize undermines your business completely. So in the next few minutes, I'm going to walk you through 3 types of clauses that every business owner needs to be paying attention to before they sign an important contract. Now, if you want this contract clarity checklist so you know exactly what to look for before you sign, just drop contract in the comments and I'll send it over to you. My name is Ramesh Shetty. I'm the founder of Signal Lawyers, an AI-enhanced law firm that helps business owners address business risks before those risks become reality. Now, in each of these videos, I'm going to share one simple thing that you can implement immediately in decision making. Now, just imagine that you've got a contract sitting at your desk and something in the language bothers you. Or maybe nothing bothers you, and that actually might be the more dangerous situation now that I think about it. Now, you might be signing these contracts for years. You've never had anything go wrong. And so again, you decide to move, you need to take action on it, so you sign. And then 6 to 18 months later, you discover that there was something you didn't understand that's going to cost you an arm and a leg. Now, what most business owners do, like yourself, is skim for the big numbers or the things that they recognize, the price, the term, deliverables, and they assume that they're not going to be suffering anything wrong with the remainder of the contract. They think it's all boilerplate. Nothing bad has happened before, nothing bad is going to happen in the future. Now, while these business owners think they might be efficient, the risk here is that they're actually being careless. Because the real problem is the clauses that create the most damage are almost never the ones that you'll understand or identify simply skimming. Frankly, they're the ones that are called the fine print. They're buried in, let's say, the limitation of liability section, or they're in the renewable terms, or they might be in intellectual property language that says that everything that you create is going to be owned by them. The fact of the matter is that standard looking language isn't necessarily standard. It tells us consequences. Because again, if you've got a standard contract, that contract has been designed to favor the interests of the person providing it. So if you're in this situation, here are 3 non-financial provisions that you need to be reviewing before you sign an agreement. The first thing is the exit and renewable terms. So this is like, how does the contract end? Does it auto renew? How much of its notice do you need to give before the contract terminates? Most businesses focus on what happens at the start. Most business owners don't identify what they need to do in order to get out of the relationship. And that asymmetry is where disputes start. Think of your phone provider or your lease. And sometimes if you miss the period in which the notice has to be given, the lease is going to auto renew, or the phone is for the other utility provider is going to renew. The second type provision is the liability indemnification provision. So indemnification is the idea that if you're liable for something, you are going to be paying some, if not all, of the cost of it, of fixing it. And so what you agree to be responsible for, and is there a cap on that responsibility, is something you need to be addressing at the outset. Because an uncapped provision means that you're going to be on the hook for something far greater than what the contract is worth. So again, if there's a liability indemnification provision, either remove it, or if you can't remove it, make sure that it's limited in some way, shape, or form. And the last provision that I recommend every business owner review and negotiate is the intellectual property and deliverable section. Now, if you are in the business, or if this contract is going to result in the creation of something, make sure that the contract is clear on who is going to be owning that deliverable or that creation during the contract and after the contract ends. This solution works because it converts contract review from something that's an overwhelming read into a targeted search that you could have a conversation about. So when you get a contract that lands on your desk, make sure that you evaluate it using these 3 categories. It takes 15 minutes, and it's simply a preliminary check that makes sure that you can either go ahead and sign it, or maybe ask someone else, like a lawyer or a business advisor, to see if you should be moved forward. The key here is not to try and do everything yourself. If you don't know the answer, find someone who does. Now, if you want the contract clarity checklist, the exact questions to ask in each of these categories, drop contract in the comments below and I'll send it over to you. You can literally open the next contract and use this checklist to identify what are the things you need to be reviewing in order to move forward with business. And again, the goal here is that you won't be the business owner that's going to be calling a lawyer to try and get out of an agreement that you'd wish you read more carefully. Chat soon. Cheers.